Hey guys, let's look at the amended gag order in the Bryan Kohberger case in Idaho. Obviously, the first step when something happens in a case is to immediately be outraged about it on social media, one way or the other. So when there's a gag order, of course, it's, oh my God, how can the judge tell people what to do? The judge has no business restricting anybody's ability to speak. And on the other hand, oh my God, how do people think he can get a fair trial if people can actually talk outside the courtroom? Everything should be secret. And distant down from that is actually reading this very short order and trying to understand it. And then third, considering whether it's legal. And fourth, understanding that there's actually two sides to this. That's what the judge does. That's why there's these scales when you're always seeing things about justice. First Amendment fair trial. And she looks at the competing concerns and tries to draft a rule that is lawful and addresses both sides of those concerns. That's what she did. If you're watching this video, you want to know a little bit about that. It's a short order. Let's hit it. The first thing to see about the order is who does it cover? So we dial the outrage back and we look at actually what is this judge doing here? So she says it's hereby ordered the attorneys for any interested party in this case, including prosecuting attorney, defense attorney, and attorneys representing witness, victim, or victim's family. So right there, that's the attorneys involved in these things. It's not the actual people, right? It doesn't say victim's family. It says attorney for victim's family. Because attorneys can be subject to some restrictions sometimes in cases that ordinary people aren't. So you have attorneys for an interested party in the case, attorney representing a witness, victim, or their family, as well as the parties to the above entitled action. And the parties are the state of Idaho and Bryan Kohberger. And included as part of the parties are investigators, law enforcement, agents for the prosecuting attorney or defense attorney. They're all prohibited from making extrajudicial statements, written or oral, concerning this case, except without additional comment, quotation from or reference to the public record of the case. And I believe it is the case that both the defendant's counsel and the state concurred on this order before the judge issued it. So they both sides think it's appropriate. But there are some other interested parties in this, not just the people subject to the order, but the public itself. Now, before you think the public has no right to know what's going on in a courtroom in America, think about that thought there for a moment. Yeah, they do. You do not want the government conducting secret trials, okay? You don't want that. Plus, we have the First Amendment that protects freedom of press and people's free speech. Now, on the other hand, you also have a right to a fair trial. That's the balancing part. In fact, the judge starts off, there's a balance between protecting the right of a fair trial for all parties and the right to free expression as afforded in the Constitution of the United States and Idaho. And she notes it's a stipulation of the parties involved. Now, the stipulation of the parties doesn't necessarily make this okay because the public has an interest in this. And she cites all the law that there is probably to cite, which are Supreme Court cases and some ABA guidance. There's no Idaho cases cited in this. So we've noticed that it's actually a pretty limited order. It's just these attorneys and the parties, and that's it. And remember, this is not a national court. For example, when they wanted to arrest Kohberger, they had to take him to court in Pennsylvania first and have him extradited. This court has a limited jurisdiction. So anyway, you can't just go around making orders that cover the whole United States of America if you're a trial court in Idaho or North Carolina or Pennsylvania or wherever. And she has not really attempted to do that, and she's tried to limit who she applies it to. So it's more limited than I thought would be based on what I heard about it. So if you're making a statement that you reasonably think would be disseminated by public communication that involves evidence involving the transactions, occurrences of the case, credibility of witnesses, parties, etc., how any tests come out, opinions on merits, any information a lawyer knows likely to be inadmissible as evidence in trial, any information likely to interfere with a fair trial under the U.S. and Idaho constitutions, such as the existence of confessions, admissions, or statements, not that there have been in this case. Nobody covered under this order should try to avoid it by indirectly getting around it. And that's it. That's all there is to this order. Now, it is being contested by a press association. And that's interesting because they are not touched on in this order. That's it. They're not part of this order. There are no prescriptions on the press in this order. And note what they said about it, that they would like to see conversations with the officials involved in criminal cases. It helps journalists understand the nuances of legal arguments and the technical steps of court proceedings, so their coverage can be fair and thorough. They dodged fair and balanced. Said Media Coalition member and Idaho Press Club president Betsy Russell. We're not lawyers for the most part, nor are our readers, and those explanations can help make sure that inaccurate information isn't spread about what's happening in our halls of justice. So they're basically saying, look, if we can talk to these people, we'll understand what's going on. And that's pretty thin there. If you're not talking about the facts of the case in particular, but just general procedure, I mean, talk to your own lawyer. Don't you people have lawyers? And I'm here talking about this, and I'm not an Idaho lawyer. I guarantee you can get lawyers in Idaho or somewhere who are willing to tell you what the next process is in the case, what this means, what that means. So as a reason to void this order by the press, this is pretty thin here. Now, they say they're going to file legal documents soon. I haven't seen that actually lay out what their legal arguments are. But they're basically saying, yeah, okay, there can be a gag order here, but this is just too broad. But the reason they say it's too broad, that we need to be able to talk to people so we can understand what's going on, to me, that seems an extremely weak argument, in my opinion. Now, the Supreme Court has set some parameters on this. It did it in a Nebraska case, which gets quoted everywhere, including in this order, where a judge had ordered that the press couldn't report on things going on in the case, couldn't even report on a hearing that was held. And that got struck down, and they put out, I won't go through it, stringent requirements if you want to do what's called prior restraint, which is telling the press you cannot report on something that is going on. You can't even publish it. That's a heavy burden. But in that case, the court noted, look, there are lesser things you can do, such as gagging trial participants if it's necessary. And that's what this judge has done, even to a more limited degree than you see in some other cases. So I don't like gag orders because I do believe in the concept of the free flow of information. Of course, I also like fair trials, and I respect the fact that the judge has to balance all those concerns. And this is no ridiculous, unconstitutional blanket situation here. There may be an error in it, maybe not. I don't know if the court looks at it, but to me, it doesn't look like it. It looks like the judge is trying to manage the press on this in a responsible way. Not everything has been sealed. Not everything has been made not public. So far, the appearances have been in the public. This doesn't cover more than the attorneys and then also the professionals involved in this case. So it's fairly limited in that regard. So that's what the order says. I've tried to show it during this video so you can read it yourself. It's not very long. And as this case moves along, hopefully the truth will come out, whatever it is. It's certainly going to find that out sooner rather than later. And I think the public has a right to know what the court system is doing with people. Defendants have a right to a fair trial, and a judge has to strike that balance. Thanks, bye.